Good afternoon and welcome. Welcome to Juvenile Law Center's fourth of five 45-minute conversations that we have been having in celebration and commemoration of Juvenile Law Center's 45th anniversary. We're so glad that you're able to join us today. These conversations have been taking place on Thursdays. We have one left. Our last conversation will take place next Thursday, December 10th. All of the conversations are posted on our website following completion, and they're also available on Juvenile Law Center's YouTube channel. We also hope that you'll want to continue to engage with us about the issues that we'll be talking about today. Please feel free to visit our website, check out jlc.org, sign up to receive our communications if you're not already receiving them. And please consider supporting our work by clicking the donate button. You can also click the donut button on our website. This information will also be in the chat room as we go through the webinar. Let me introduce my esteemed colleagues who are joining me today in this conversation. Dr. Tami Benton is with us. Dr. Benton is the Psychiatrist-in-Chief, Executive Director, and Chair of the Department of Child and Adolescent Psychiatry and Behavioral Sciences at the Children's Hospital of Philadelphia. Bob Schwartz is a co-founder of Juvenile Law Center and Executive Director Emeritus. Abd'Allah Lateef is a Senior Strategic Advisor and Racial Equity Specialist at the Campaign for the Fair Sentencing of Youth. He also spent about 3 decades in prison and has been home, thankfully and wonderfully, for about 3 years. Welcome to all of you. We're going to start with Dr. Benton, who is going to give us the background, sort of lay the groundwork for our conversation about how the law has evolved for adolescents and children in the justice system.
So thank you, Marsha, and I'm really glad that I could be here with all of you today. I want to provide a framework for thinking about adolescents and how they think and how they make decisions. So I want to provide some context for thinking about adolescent thinking and decision-making from a developmental perspective. To start, I want to define the period of adolescence that I'm discussing. So the World Health Organization, and that includes us in the United States, defines adolescence as a time period of between 12 to 25 years. And it's a phase of development that marks the transition from childhood to adulthood. We all see the physical changes of this phase very clearly. We look at these developing individuals who are becoming interesting young adults, but most of us in this meeting who have ever interacted with adolescents find ourselves asking, what on earth were they thinking? And it's a good question. And that's because what they're thinking doesn't match what we're seeing. What is happening in the body and what is happening in the brain don't really match. And while the major physical changes of puberty are almost complete by 18 years of age, the development of the adult brain is not really complete until they're in their 20s. And what we're also learning with advances in neuroscience is that continued experiences will mediate the changes for all of us through the age of 30. So what is it that we know that makes adolescent neurodevelopment different? We recognize that the behaviors that we see in adolescence that we identify as risky are all driven by brain mechanisms that are still immature. So brain development happens from the back of our brains to the front of our brains. So for babies and infants, the backs of their brains develop first. We call those the occipital lobes. But those things drive things like reflexes, sucking, eating, crying. The development moves from back to front. So the front portions of our brains, described as our frontal lobes, which are responsible for what we call executive functions, is responsible for things like attention, impulse control, thinking, planning, inhibition of our behaviors, thinking about the consequences of our behaviors, planning ahead, and judgment. And when we think about teenagers, we have to think about those changes happening in the context of all of the emotional development that's also brain driven, but it's happening faster than their ability for planning and impulse control. We all know from interacting with adolescents, and for those of us who don't, what we read is that there's greater risk for lots of things for adolescents. They are much more often engaged in alcohol and substance use. They don't sleep, which actually is a risk factor. All of those things can lead to episodic brain dysfunction or disruptions in development. So then what are the consequences of all of these changes? Well, the consequences for adolescents that we all see are, one is greater risk taking, and that results from biologically driven brain mediated mechanisms that really focus their attention more on reward seeking, so that their social emotional systems of the brain is much more focused on reward seeking and much less sensitive to avoidance of harm. There's greater sensation seeking related to hormonal changes, less buffering of those sensation seeking activities. And then the biological changes that happen in the brain motivated by hormones actually increase their attention to social stimuli. So peer behavior and social status are really, really prominent for adolescents, driven by their biological development. And then interestingly, in the face of all this, the centers of their brains that respond to negative feedback are much less developed than the areas of their brains that actually respond to reward. So we know from gambling tasks where we study teens, driving simulations, risk-taking games, they're much more likely to respond to the possibility of reward, even though the consequences could be very negative. So then what do we see when we look at the adolescent and their decision making? You know, what we see are impaired judgment in situations that have any kind of ambiguity or requires careful thought. They make bad decisions in emotionally charged situations that require reasoning and judgment. And then their immature judgment relates to their ability to weigh risk and the benefits of their decision making. And then the end results of this are their impaired capacity for long-term and short-term views on the consequences of their behaviors. And then more importantly, and this is an essential point, that one of the things that we are learning more through science is that the judgment and decision-making for adolescents who are exposed to violence, traumatic experiences such as witness violence or physical abuse in the home, neglect, those youth are disposed to making poor decisions, even in the context of all the things that I've just described. So on the upside, we all know that adolescence is also an opportunity for change and improvement. And so the concept of neuroplasticity, the ability of our brains to change over time, gives us an opportunity to reshape the brains of adolescents so that adolescents and adults up through their 30s who are exposed to positive experiences focused on changing the negative behaviors that may already exist or adverse experiences are open to change, and that we have an opportunity to shape that. So despite the risk, despite the challenges, there's opportunities for us to create meaningful change for adolescents who make bad choices. And on that note, you know, I will hand this discussion over to Bob.
Thank you, Dr. Benton. So Bob, we're hoping that you will give us some insights into how all of this scientific knowledge has had an impact and an effect on the legal developments involving kids in the justice system.
Sure, and you know, first, thanks, Marsha, and it's really an honor for me to be on the same panel with Dr. Benton and Abd'Allah, and to see you again, which is neat. I'm going to try to put the research and the legal and developmental framework into a historical context, and I'm not going to go all the way back 45 years, so you can relax about that. But I do want to start with a case we were involved in 30 years ago. The case of a 9-year-old boy who was from upstate Pennsylvania who shot and killed his 7-year-old next door neighbor. He was 9 years old, but Pennsylvania has no lower age limit for homicide, and he started in the adult criminal court, where he was kept by the trial judge. The trial judge said he was adult-like, in part because he lied when he was asked whether he did the offense. The trial judge said, adults lie, this boy lied, therefore this boy is an adult. A syllogism that doesn't work outside of some courtrooms, apparently. He also kept the boy in the adult system because he showed no remorse, apparently, in that he kept falling asleep during the very exciting hours-long pretrial proceedings. So it took us years to get that case reversed on essentially a technical ground based under Pennsylvania law, in part because we didn't have the tools, the developmental research of the sort that Dr. Benton just described. Most we could say were things like 9-year-olds don't appreciate the finality of death. That was also part of a time when states were getting tough on kids, and there was a really punitive approach to juvenile justice and justice in general in the United States. So speed forward to 1995, a couple things happened that year. Princeton criminologist John DiUlio in the Weekly Standard wrote an article called The Coming of the Super Predators. It was an enormously influential article that was entirely wrong. It proclaimed that there would be a generation of kids who were super predators that were wired differently than other children somehow to commit horrific crimes. That same year, Lori Garducki at the MacArthur Foundation tapped Temple University's Larry Steinberg, developmental psychologist, to lead a research network on adolescent development and juvenile justice that began a 10-year process of research that was influential in grounding many of the principles that Dr. Benton just described. So the super predator myth on the one hand and the well-grounded research on the other on adolescent development were two ships going in different directions. Super predators were a myth, but they were a myth that reinforced and embedded policies that we're still trying to undo today. The research network led to a paradigm shift in the social sciences and neurosciences, as you heard from Dr. Benton, that has enabled advocates, inmates, family members, so many people to steadily hammer away at the edifice that the super predator myth created. So not only have we as a field been trying to smash away at that punitive regimen, but we've been trying to build a completely different system. 20 years ago, in 2000, there was a meeting at Northwestern Law School. Bernadine Dorn, Patty Purett, Steve Harper, Steve Drizzen, Connie de la Vega, and others, including me, planned a campaign to end the juvenile death penalty. It was a multi-pronged campaign with many players that culminated in 2005 when the United States Supreme Court decided Roper against Simmons. Roper ended the juvenile death penalty. In Roper, the Supreme Court relied on the developmental research that Dr. Benton just described. The Supreme Court pointed to three particular aspects of that research. First, they pointed out that children, as Dr. Benton said, lack the maturity and an underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. Second, they pointed out that children are more vulnerable to negative influences and outside pressures, including from family and peers. And importantly, they have limited control over their own environment. Dr. Benton spoke about the trauma that children have. They can't escape, the court pointed out, often horrific crime-producing settings. Trauma is all around them. And third, a child's character is not as well formed as an adult's. And this is important, something that Abd'Allah will speak to in a moment as well. The youth's traits are less fixed, and his actions, the court said, are less likely to be evidence of irretrievable depravity. When Roper came down, Marsha will recall, we wondered at the time, was the decision ending the death penalty merely about the death penalty, or did it have something to do with children and adolescent development? I thought, frankly, that the case was about the death penalty, since the Supreme Court rarely got involved in reviewing the severity of sentencing outside of the death penalty context. The good news, of course, is that I was wrong, and wrong in a very big way. The case was about children and the Constitution, and that became clear in the years that followed Roper. There's a number of Supreme Court cases that made this point and reinforced the developmental framework. In 2010, Graham versus Florida, the Supreme Court said that life without parole for crimes committed before the 18th birthday was unconstitutional in non-homicide cases. The Supreme Court in that case, in Graham, made it clear that the Constitution recognized the developmental issues like those discussed by Dr. Benton, and they made it clear that Roper wasn't applicable only in homicide cases. In 2012, the court decided Miller against Alabama, deciding that mandatory life without parole for juvenile offenders was unconstitutional. And then in 2016, the court made Miller retroactive. It said that the principles laid out in Miller versus Alabama that require the court to look at a whole list of factors that were related to adolescent differences and the ability of kids to change in the years ahead, that should be applied retroactively. And that had a huge impact, as you'll hear, on hundreds and hundreds of juvenile lifers, including some 500 in Pennsylvania alone. The major point that was reinforced in Montgomery was that the court clearly said children are constitutionally different from adults for purposes of sentencing. And I'd be remiss if I didn't say how gratifying it is to know that Juvenile Law Center participated heavily in that string of cases from Roper to Montgomery, with Marsha having a leadership role in organizing and drafting amicus briefs and in serving as co-counsel when Montgomery reached the Supreme Court. Together, these cases have had a ripple effect, not only in criminal court, but in the juvenile justice system as well. Those cases and have led to state Supreme Courts addressing these issues and state legislatures changing laws affecting how kids are treated when they're in the adult system. One aspect of this is the change in mandatory minimum sentences, which those sentences never distinguished how old you were at the time of the crime. So if there was a mandatory sentence, let's say 5 years for a particular offense, if you were tried in adult court, it didn't matter whether you were 14 at the time of the crime or 45 at the time of the crime. Yet, in recent years, state Supreme Courts in Washington and Iowa have struck mandatory minimums applied to children who were tried as adults. States like California have addressed the issue of parole hearings for those convicted as adults for crimes committed before their 18th birthday in California. And in fact, California, recognizing the point about adolescence that Dr. Benton made, recently changed those laws to affect more frequent parole hearings for kids who are under 23 at the time of their offenses. There's a whole movement now around the area of emerging adults, those, depending on the group, 18 to 21, 18 to 25, who are still developing in terms of the social and emotional factors that we heard about well into their 20s. So some jurisdictions have created specialized young adult courts to address those children with different procedures and sentencing schemes. And some states are considering raising the age of juvenile court jurisdiction above the age of 18. Vermont, a couple of years ago, for example, raised the age to 21 for almost all offenses, other than a few very serious ones. I say, despite the developmental research, though, there's so much more to do. I mean, one example of this is the fact that Brandon Bernard, who is now 40, is due to be executed by the federal government 1 week from today for a murder that he participated in when he was 18. That the message of on adolescent development and the capacity for change, despite all of the changes he has made in his time as a model prisoner, has not been noticed by the current Department of Justice. Finally, I would just mention that with limited time, that the impact of this research has been felt on the youth legal system as well. There's an increasing movement to divert more and more cases from the court, recognizing that the developmental pathway will do as much to change youth behavior as the court system itself. And diversion from incarceration, which interrupts normal development, is happening more and more as detention and incarceration declines in the youth justice system. And there are many other aspects of that system that are probably a topic for a different webinar that have been affected by the developmental research. So I just conclude by pointing out that even though we have come a long way in the last 30 years, from when we could see a 9-year-old tried as an adult to the point where states are considering treating young people over 18 as youth, there's a lot more to be done. And I'll pass it over to Abd'Allah, who can give us a taste of what's to come.
Thank you, Bob. And Abd'Allah, you have a unique perspective. You have lived on the inside and you're now living on the outside. As I said, thank God, we're also happy to have you back with us and in our community. You're an advocate now for criminal justice reform. And I think it would be great for our listeners to hear about how your personal experiences have informed your advocacy, but also your own vision for criminal justice reform.
Yeah, thank you for the warm welcome. It's always a pleasure to be welcomed into a community that is as gracious as Juvenile Law Center. And of course, you were my attorney representing me throughout the.
I feel like you did more of the work.
Well, indeed. But yeah, and with all of that, just from Roper up and throughout Montgomery and leading up to my resentencing. And so the privilege that I have to stand in this place, in this space as a free person is in large part due to the efforts of you personally and Juvenile Law Center more broadly. So always particularly grateful for you and for the work that you do that enables me to share this space with you all. So I will talk about my experience and leading up to the advocacy work. And as we talk about my experience, needed to be rooted and grounded in the information that both Robert and Tami shared. And certainly the academics in terms of what we've learned recently about neurological development and how adolescents develop is a fascinating study, and it's something that obviously impacts the legal decisions and the progeny of cases that Robert had referenced, starting with Roper, going up through Graham and Miller and Montgomery, where the court has fundamentally recognized that children are different for purposes of sentencing. And I would just caveat that it's not just for the purposes of sentencing. Children are fundamentally different from adults, period. And that's something that many parents knew. That's something that I certainly knew, even though I thought I was grown. I was not a miniature adult. I was, in fact, a child. and suffering from the very deficits that Dr. Benton spoke of, but also that the court came to realize some decades later. And so the gravity of where we are in the moment in light of these developments, both in terms of the science and in terms of the law, while there has been a lot of progress, there is certainly a long way to go to ensure that the law matches what we know with regards to the science and adolescent development and how we treat children who commit harm. And so, much like myself, many children are and have been subjected to peer pressure, to impulsive behaviors, actions that are informed by all of those things that Dr. Benton spoke to and that the United States Supreme Court came to recognize. And as we recognize and grapple with those things, then it suggests that the way that we respond to children who have committed harm should be in comportment with what their diminished capacity is. And that we shouldn't be looking at children to hold them to account in the ways that we think that is appropriate for adults. That's certainly inappropriate across the board. And so for me, spending 30 decades in prison and going into the prison essentially as a child and being subjected to all of the horrors and the gross wanton neglect and abuses that the prison environment produces, there was an opportunity for one of two things: to either try to transcend beyond all of the deprivation and all of the descriptors that the court and the society imposes upon children who have committed harm and people who are incarcerated in general, to try to transcend that or to internalize that. And I've been in situations where I've saw both sides of that. Children who have internalized how they were described as child predators, how they were described as monsters, how they were described as people who were less than human, and begin to internalize those things. And others had a bit more fortitude or a different perspective or the assistance of other prisoners to help them navigate through that process to understand self-identity. In my personal case, it was a combination of having older mentors and this process of maturation, where despite all of the violence and wanton neglect and abuse and lack of opportunity that exist in prison, I was able to mature into the fullness of my own self-awareness as an adult. And those morals and manners that were instilled in me as a child from my parents began to fully bloom and manifest. And so my personality kind of solidified, and that informed my trajectory. And so it's not the prison environment that produced who I became. It was that nurturing from my parents and the unwillingness to accept the narrative that I was a dangerous predator, murderer, monster, the unwillingness to accept that and to internalize that, and to really begin to understand that the system's way of responding to the harm that I caused didn't mitigate the harm for myself nor for the families who my crime impacted. In fact, it only exacerbated that harm to myself, to my family, my community, as well as the victims. And that was the impetus for me to not only try to survive the horrors of prison, but to also try to ensure that those practices that enable me to have that outcome would be changed for others as well. And so that began the process of advocating and trying to change the narrative that was then around the prominent narrative about children being child predators and adult crime equals adult time and all of those nonsensical monikers that were used in political spaces as well as in law enforcement that really depicted children in a way that belied the realities of child and adolescent development. And so, yeah, just ultimately having the ability to raise voice awareness and collaborate with organizations such as Juvenile Law Center, YSRP, and the campaign that I now work for, National Campaign for Fair Sentencing of Youth, to change the narrative, to create changes in laws that will enable other children, formerly life sentence children, to be resentenced and to be released. And that work kind of continues on the outside, not in the capacity that I have working with the Campaign for Fair Sentencing of Youth. And although my work at the moment is centered in being a strategic advisor and advancing racial equity, the thing that drives my passion in this space is the fact that I've recognized that there's a gross disparity and inequity with how children of color, Black children in particular, are treated within the criminal justice system or the legal system. And realizing that, what I came to realize more than anything is that this notion that we don't know what to do with children who commit harm is a fallacy. And what proves that is the fact that when white counterparts, children, commit the same harm or even more egregious acts of harm, there's a willingness to find value and alternative to life without parole and other extreme sentences because of the value that is attached to that white person, that boy or girl, as it were, that child, as it were. And that's perfectly fine, and that's how it should be. But when it comes to Black and brown children of color, there's less of a willingness to find value and alternative to extreme sentencing. And so that suggested to me that there's a greater need to infuse racial equity within our sentencing procedures, policies, and processes to better inform better outcomes for children of color. And so my work is primarily engaged in trying to infuse that racial equity into how we treat children who have committed harm. And then finally, there's this piece about what the drivers of crime, particularly in communities that are hyper-marginalized, that creates those outcomes as well. And getting in the front end is not just about what is the appropriate means of accountability and what is the appropriate punishment for children who commit harm, but it's also doing those things that are necessary to ensure that harm isn't perpetrated to begin with. And part of that is about infusing an equity lens into these communities that have been hyper-marginalized so that we begin to address those things that are the drivers of crime and that enable children who cannot extricate themselves from the environments in which they live to create other opportunities to access pathways to prosperity without thinking irrationally, as it were, that crime is a way out. So we're also looking to engage in that type of work to work on the front end to bring equity and resource to communities that are hyper-marginalized and historically disadvantaged as well.
Thank you, Abd'Allah. I want to just alert folks who have joined us today. The chat room is open if you have questions. We certainly will not be able to get to very many of them, but we will try to get to a few questions if we can. I know we have one that we're going to get to in a minute. And I think the question that was put forward about ACEs, which I'm going to ask Dr. Benton to address in the first instance, I think is really relevant for two reasons. Number one, Abd'Allah, I think your centering race in this conversation is so essential, and I thank you for doing that. We all know who work in this space that it's impossible to talk about the justice system or to think about reform without addressing the racism that is at the center of the system. And I know that there has been criticism of the ACEs test, and Dr. Benton, I'll let you describe exactly what that is as to whether or not that itself also is a reflection of racist attitudes in the country or perpetuates some of that. And then I think the other point that you made, Abd'Allah, that I think is also related to this question about the use of ACEs in the courtroom is that really in spite of and despite what you experienced in prison, you excelled. You matured, but you also excelled. And you demonstrated, we talk about resilience, but I feel like you're beyond resilience, but you just really demonstrated that individuals, they will grow and mature and they will become who they were meant to be. Whether there are programs in that prison or not, programs would be great if we had them. You didn't have access to them, and yet you still became and grew into this remarkable human being. And so to connect that to my question about ACEs, sort of working off of the question in the chat room, also I think, Dr. Benton, this notion about, sort of putting kids in a box, giving them labels and putting characteristics on them in a way that actually doesn't let them move beyond them. So if you could speak to that.
Yeah, so in terms of the ACEs, it's a really good question. The ACEs are the Adverse Childhood Experience questionnaires. They were actually developed to be administered to adults so they could retrospectively talk about their childhood experiences. And typically, the questions are about exposure to physical abuse, sexual abuse, neglect, and or psychological abuse. And the goal of the ACEs is to identify which of those experiences may predispose you to some future risk. Most of it's been tied to physical health. So how does adverse childhood experiences predispose you to heart disease, cancer, other things, including poor psychological outcomes? So that was the goal of the ACEs. One criticism of the ACEs in the field is that it's not tied to an intervention. So understanding that something happened to someone when they were young doesn't tell you what you should do about it to change an outcome. The other thing is the ACEs really identifies risk. It doesn't predict outcomes. And so when we say that, we look at someone who's had adverse childhood experiences like abuse or neglect, it doesn't predict that you will be a bad person or you will do bad things. In fact, what we know from the ACEs is that for most young people who are exposed to adverse circumstances, they actually do pretty well. They're quite resilient. And when we look at inner city communities who are given the ACE surveys, what they learn is that for kids who live in adverse circumstances, particularly African American and Latinx youth, they actually don't respond in a negative way to many of the adverse childhood experiences that young people from affluent communities might respond to. And so I think we need to use the ACEs in context, that it's a measure of some experiences that individuals have had, but individuals differ in their response to adversities. So that the ACEs should not be used as an instrument in any setting that predicts that people will be bad or that people will have bad outcomes. What it provides for us is a framework for understanding individuals' experiences, some of which may have led them to where they are right now. And so that's a framework for understanding the ACEs.
Thank you. And I think for our colleague who put that question in the chat room, I know there was also a specific question about the use of ACEs in the courtroom. And in a sense, I think that Dr. Benton just answered that, which is so often it's about understanding context. And ACEs it's not about predicting outcomes. I think that's a really important point that you made. And it's also not about being determinative of what intervention will or will not work. And I think also the fact that it's very much in a way about predicting exposure or risk for physical health is an interesting point to remember. Bob, I wonder if you could speak a bit more about, as we think about the work going forward, obviously the sentencing cases have had very significant reach across the country in terms of how we have thought about youth in the adult criminal justice system. But I think, to Abd'Allah's point, that this is not just about sentencing. This is a much bigger story about how we should be viewing youth in the justice system, whether the juvenile system or the criminal justice system. If you could just speak a little bit more about how you see these tentacles from the sentencing cases spreading out as we think about reform work going forward.
Well, one thing that's worth noting is that we've had something of a natural experiment this year with the pandemic. So, which I think is going back to Abdullah's point about the maturation process and the growth resilience that naturally takes place. We've seen communities across the country release children from detention centers and places of incarceration and do quite well in the community. That youth incarceration, like the adult incarceration that Abd'Allah described, is rarely very, very effective. So the movement now against the use of what we call deep end incarceration after youth are adjudicated delinquent is ongoing, and I think will continue. We don't need these places. Resources can be transferred, but resources could be transferred in ways that give kids opportunities. And we've had an experiment, for example, here that's worked quite well in Philadelphia, led by a former deputy police commissioner, Kevin Bethel, in which children who used to be arrested in schools were referred for voluntary services if they wanted them from community-based organizations supported by our Department of Human Services. It was purely voluntary. There was no recrimination if kids didn't participate. Huge success rates in that we didn't need juvenile court to be the school-based disciplinarian, as an example. We've seen the developmental work play out with respect to interrogations in the JDB versus North Carolina case, Marsha, that you were involved in, that the Supreme Court decided in 2011 that a child's age and maturity is relevant for determining whether a child is in custody for purposes of Miranda warnings. That, this was a 13-year-old who was in a unlocked room with a lot of adults who were questioning him, and the North Carolina Supreme Court said, of course, the kid should have known that he was free to leave at any time, which is, of course, absurd, and the Supreme Court recognized it as absurd and held a different standard. So, I mean, there's issues from interrogation, voluntary consent, diversion, the way interventions are done. There's a whole movement now in the youth probation world to eliminate conditions of probation and technical violations of probation that end up with kids being incarcerated, because kids can't keep track of 20 conditions of probation, most of which are unrelated to their original behavior that brought them to court in the first place. So the developmental research is rationalizing in many ways the youth justice system, but there's still a long way to go.
On that note, and it is true that the pandemic is teaching us, I hope, some positive lessons. I think in many respects, we're also leaving youth behind. And that's a topic for another day, something to revisit as we have time to reflect. I want to thank Dr. Benton, Bob, Abd'Allah for joining us today. Thank you so much for your wisdom, as always, and for your insights. I want to thank everyone who has joined us today to join in this conversation. I hope that you will continue to follow Juvenile Law Center's work and to connect with us through our website and other social media. Please stay tuned for our last and final conversation, which is next Thursday, December 10th, same time, same place. And of course, I invite you again to learn more about our work. And if you are interested in supporting us, please do hit the donate button and not the donut button. Thank you, everybody. Have a great day and stay healthy.
Thank you.